Do you know what's new for nurses? What about dementia and caregiving? Are you looking to grow as a leader? And what are the current healthcare leaders doing for you? Welcome to the Angie Graham Podcast. If you've ever wondered what it takes to go from caregiver to executive director, well, this episode is for you. Maybe you want to take a seat at that leadership table, and this industry definitely needs more leaders. And you want to understand what it takes to be an executive director and also understand the legal around being an executive director, because the truth is the higher that you rise, the more you need to know to protect your residents, your staff, and your career. Today, we're going to hear from someone who understands both the clinical side and the legal side of senior care. Robert Lightfoot is a healthcare attorney, a registered nurse, and a longtime trusted advisor in assisted living. He's helped providers navigate compliance, license risks, and regulations for years. So if you want to grow as a leader and avoid costly mistakes, step into the executive responsibility with more confidence, then you're in the right place. Welcome, Bob.
Hi, Angie.
How are you doing?
I'm good, thanks.
So I didn't know that you were also a registered nurse. So tell me, were you a registered nurse before you were an attorney, or an attorney before you were a registered nurse?
I was a nurse before I was an attorney. It was my nursing career that actually got me interested in legal. I did a lot of oncology work, and a lot of sort of legal ethical questions arise in that arena. Of course, this was in the mid 80s, but one of my coworkers said, well, why don't you go to law school and get your questions answered? And I thought, well, maybe I should. I've always had always thought about that. So I did it, and been 10 years as a nurse and about 30 years as a lawyer now.
Well, outstanding. That is outstanding. So in the world where the public hears so many negative stories about assisted living, one of my missions was to bring to light all the things that we also contribute as an industry and the things that we do right. And there is the worst of the worst about providers out there. If you were looking for a place for one of your loved ones, what would you look for today?
Well, as you know, brand new and shiny is very attractive. And there are a lot of great providers that build brand new and shiny. But the real heart of, in my opinion, really good experiences in care is at the caregiver level, and the people that touch your relatives on a daily basis and interact with them. So in that regard, I think you really want to look at the quality of the leadership in the facility, the quality of the care staff. It's kind of a maybe a little bit overused term, but if they love your family member, that's where I want to be. I don't care if it's a 50-year-old facility or a 10-day-old just opened facility. If that care staff shows the compassion and love for my family member, that's where I want them to be.
Great advice. I agree. One question I've always had is, from a legal standpoint, is a provider allowed or should they avoid saying sorry? Because sometimes things go wrong, and what would you advise a client in that situation?
Well, interestingly enough, we do have an I'm sorry law in Wisconsin, which permits healthcare providers, and since we're, specifically talking about assisted living, it does cover CBRFs, adult family homes, and RCACs, residential care apartment complexes. So a staff, a leader, anyone in the facility who feels like they made a mistake can say, I'm sorry. And that cannot be used in a court of law to prove liability. So we do have that. I think every situation, though, is unique, and I wouldn't just jump right into, I'm sorry as a default every single time someone feels like they made a mistake. They should discuss it with their leadership. They should discuss it with their legal counsel to see if that's appropriate. Because obviously there's different stages. Something could have just happened, or something happened a year ago. Now there's a lawyer involved, and do you apologize a year later? Who knows? The best thing would be to think through it, look at what the issue that caused you to think about saying I'm sorry is, review our law here in Wisconsin on whether or not that is going to be appropriate, or should it be appropriate. So I think there's a lot of considerations, but the bottom line is we do have a law that protects people here in Wisconsin. And yeah, you can say I'm sorry. It's not going to affect the outcome of a lawsuit one way or the other.
And we're in a highly emotional business, as you know, because you're dealing with families with their precious loved ones at end of life, and no provider ever wants anything to go wrong. But the truth is, we are dealing with people. We're dealing with residents, We're dealing with staff, and there's times that, they just need to feel heard. And navigating through that, I always want to be able to show empathy for what families are feeling, because there's a wide array of feelings, of course, that go on. How, now that we have this technology, these cell phones, these walking video cameras and pictures, any recommendations on, you'll get families that come in, or even team members for that, and they want to record or take pictures in that care setting. How should providers or directors be navigating those situations when they're trying to document things that may be going on in the building?
Well, there's some pretty strict don'ts, and then the rest of it's kind of fluff, to be honest with you. So I think the strict, if you want to look at it strictly, there's no recording of a resident without their permission. There's no recording in a common area where other residents can be seen. There's no recording in any other patient areas like treatment rooms or anything like that. And then everything else is kind of, you have to think through it. There is some guidance that Wisconsin DHS has put out, but it's not real specific. It's
vague. Yeah.
It is vague. And so I get a lot of calls on that. They've read the memo, they've read the guidance, but they still have questions. But I think if you start from a really good HIPAA idea that you cannot film someone, at least a patient, without their permission, number one, that's the starting point. Then if you also realize that you can't have a camera in an activity room or a dining room or, anywhere you might find a patient or resident, that's again off limits. But the technology is changing so rapidly. It's very hard. And many states have what they call granny cam laws, which are very specific. I've even seen some that permit cameras to be in patient areas, but that's not Wisconsin. So one thing you have to also start with is making sure staff know the ground rules. Many staff don't know. And, it's harmless, I guess, at a birthday party for a 100-year-old resident for staff to be taking pictures, but you really should have a policy on that. And it all goes back to your company policies. What are your policies on this? Train your staff on those policies. Make sure everyone's aware and constantly reinforce those policies with stand-up meetings and in-services, so everybody knows what the ground rules are. Now, even though you have these ground rules, things are going to happen, and you're just going to have to deal with that as it arises. But if a resident insists, they can have a camera. If a family insists, it's a little more gray depending on whether the resident has an activated power of attorney or a guardian, because then you want to kind of get a little bit behind, well, what would the resident have wanted? And that's not always clear, especially if someone's advanced in their dementia and can't express what they would have wanted. But I can tell you this, I don't care what family member comes up with the notion that the camera has to be on all the time, but I don't care how further along my dementia might be, there is no time I would ever want anyone to film or take a picture of me when I'm getting up to go to the bathroom, getting dressed, getting my bed changed, or getting cleaned up from an accident. And I don't know anyone that would want that. Now, you're going to probably get some pushback from families and residents on some of those issues because, they're looking for like abuse situations. And that's another thing I would urge is when a family or resident wants a camera in the room, talk to them, find out, well, why do you want a camera? Maybe they've had something gone missing or something, and that would be a legitimate reason. But sometimes the reasons are not necessarily not legitimate, but you can accommodate the reason they wanted a camera in other ways other than putting a camera in the room. So, that I know
dignity.
It's
definitely
dignity.
Yes.
Yes.
Dignity issues. I agree. And unfortunately, if it gets to the point that families insisting a camera be in there 24/7, there's definitely a trust issue between the family and then the provider. And that's a whole nother issue instead of, can of worms, I would say also.
Yeah.
But is a family...
Maybe suggest to the family at that point, maybe we're not the right facility for you. If there's not any trust and, you're going to want to see your mother getting changed or getting up to the bathroom, that's, those aren't our values here. And maybe we're not the right fit for you. It may be that because, these are kind of serious issues. HIPAA issues transcend state regulations and they get into more federal issues. And although we're not federally regulated in Wisconsin or any state in assisted living, you don't want to have to make a report to the federal office, the OCI. So, we don't do that.
Yeah, I totally agree. But family members, if they come in with their recording devices, they're not bound by HIPAA, are they? If they're not...
No, they're not. They're not considered healthcare providers. So HIPAA only applies to
the staff.
To the staff and healthcare providers, correct.
We're Talking About It is brought to you by Our House Senior Living. Visit us at ourhouseseniorliving.com.
Is there any legal ramifications around if a family member comes in and records, the whole dining room during that? And sometimes it could be harmless, but they record the whole dining room during that birthday celebration or that event that's happening at that, and then they post it out on social media. Is there any liability to the provider if something like that happens?
There could be. I've not seen it because it's not an act by the provider. So I have not seen DHS or any other entities complain about that. I could see how it could be an issue. The best thing would be just to have a private meeting with the family and say, hey, there's healthcare going on here. We can't have you doing that. The only way you could do it is if you got consent from everybody that you're filming, or you film it separately if you want to. It's pretty hard to regulate. I mean, the devices are small. Sometimes you can't tell if someone's talking on their cell phone or filming someone. I mean, you really don't know. So you do the best you can. But a private conversation, if you see that going on, is probably the best thing.
So to any family members that may be watching, if you have a loved one in assisted living, you just do have to practice some respect to the others that may be there. There's nothing wrong with getting photos and videos of your loved one, because that's what we do as families, and we want to share that. And nowadays, that's how families share, is on social media. But you do have to be aware of the other individuals that are there.
It's their home too. I mean,
yes.
It's their home too. And if they don't want to be filmed, they shouldn't be filmed.
We have a lot of residents that love being filmed. They love that attention. How many likes did I get?
Yeah.
What were the comments?
Yeah.
So, here's the thing. We're always scared of social media to a certain extent, but there's also that part of social media that families do get to see their grandparents that, they might be in other states, and they like to see those things going on.
Right.
And then we've learned that also residents like the attention. They like to, how many people liked it? They have questions about it. So it's a whole new world compared to years ago.
It sure is.
And we get a little frightened, quite honestly, as a provider, you get a little frightened of social media, because you're always like, is it too much? Or, what can we do? What can't we do? But it's so ingrained now in how we live our daily lives.
Right. And to that, going to your point there, again, it would be good for assisted living facilities to have policies, and not just on cameras, but social media use by staff. I mean, I see the gamut from facilities that strictly prohibit a cell phone being brought, into the care area, to, you can use it, but only on your break, type of thing. And, you as well as anyone know that from time to time, unfortunately, you do have pictures and video posted on social media that staff have taken. And again, this just reinforces you should have policies. You should reinforce those policies, teach those regularly, bring it in front of people when you have to do continuing education with them. It's important.
It is very important. It's something we try to stress with the staff, because there are legal ramifications around that for them, as well as a provider, but specifically for them. I mean, it's some potentially long jail time and
HIPAA
fine
around
that,
and the whole HIPAA violation. Yep,
for sure. If something does go wrong, what are the first action steps do we need to take in that first 24 hours?
With video or with anything?
With anything that goes on in that care setting, something goes wrong. What's the first steps in the first 24 hours?
The first thing is there's a couple things that it would be first things, but in my mind anyway, and that would be, you have to determine if the incident's reportable. So remember, if your CBRF, in addition to abuse and neglect, which is, that you have to look at that separately, there are things such as, law enforcement being called, elopements, suspicious deaths. There are things that are subject to the regulations that have varying degrees of timing in terms of reportability. So abuse and neglect, facilities are actually permitted to do investigations before reporting. And that's different. Nursing homes have to report any allegation right away, then do an investigation, then determine what the outcome is, and then report the outcome. Assisted living is different. There's discretion, 72 hours of discretion to do an investigation and determine if it was actually abuse or not. But when you're looking at things like serious injuries or accidents, and again, the word serious injury, not a defined term, but yet something we have to deal with. If there's a serious injury, there's a reporting that has to be done to DHS for that. Law enforcement, as I said, elopements, suspicious deaths, all are things that are subject to report. So the first thing is just determine if this is a reportable incident or not. So that would be number two would be to immediately start some sort of investigation. Obviously, if you're looking at an abuse situation that's more serious, and your investigation is going to have to be very detailed and follow very meticulous steps and procedures, and then a state reporting form and all that. But if it's a fall, for instance, or something that's not abuse, it still should be investigated. Falls and a lot of other clinical things are the things that get the most attention at DHS. So anything clinical, med errors, medication mistakes, falls, incidents of abuse, again, are all things that are going to be heightened for you to have to take additional steps in terms of determining root cause, doing an investigation, determining outcome. And some of that might even run through your quality assurance committee. I'm hoping most people have quality assurance committees at their companies or facilities. I think some of the smaller providers probably don't, but that's one way to protect some of the inputs and some of the documents that are generated in an investigation, is to put it through quality assurance, because things like incident reports really are not medical records. They're records that quality assurance review processes use to improve the care, quite honestly. And to have to divulge all that is something we necessarily don't want to do. So the first thing would be reporting. Kind of co-equal with that would be some sort of investigation, and then looking at trying to remedy, once you determine what the cause is or root cause is, trying to remedy that situation. And then again, you're probably going to have to do teaching on that and repetitive teaching on that issue to make sure that you don't have a recurrence of that issue.
Sure. My mom lives in assisted living, and I know sometimes my family members will ask me, well, why this or why that? And I think a lot of families don't understand all of the behind the scenes regulatory things that providers have to do, and the hoops that we really have to jump through when it comes to maintaining our license and as well as providing that quality of care. But one thing that comes up often that I've heard throughout the years, and other providers, and even with my own family, is residents that may want to eat their meals in their own rooms in that CBRF setting. What are the risks for a provider if a resident, so there's that thing, the resident rights, as we know.
Yeah.
And they'll say, well, isn't it my right to be able to eat my meal in my room? But then there's also that concern as a provider. So in that scenario, what would your recommendation be?
Well, you're absolutely right about resident rights. And I can tell you, with the home and community-based services rules implementation, by the way, goes into effect in 6 days, April 1st.
Wow.
It's going to start being surveyed on. And it has been reviewed up to this point, but no actual citations are going to be issued until after April 1st. When you do have a survey inspection. So you do have to be cognizant that one of the big ones here is self-determination. And so if someone wants to eat in their room, if they want to have a visitor at 3 a.m., if they want to have a Big Mac at 7 a.m., they pretty much have the right to that under home and community-based services rules. And it's going to be looked at much more closely and regulated here in a few days. So if someone wants to have a meal in their room, there are some cautions, you'd have to follow. I would be cognizant, especially of people with swallowing difficulties that have to be monitored, because not necessarily does someone with a swallowing issue have to be not fed, but there's like visual monitoring that has to occur because of the risk of choking. And this has come up. I know that one of the regional directors in the southern region in Wisconsin is particularly concerned about the number of sites that have come up from choking and swallowing. And it's not always due to a lack of supervision. Many times it's because the resident chooses not to follow the doctor recommended diet. So if someone has a swallowing difficulty and they're recommended, thickened foods or liquids, and the resident's just eating whatever they want, obviously that's a risk to them that they're taking on. They have the right to do that. It kind of falls under right to refuse treatment. But the facility's probably going to be charged with enhanced supervision of that resident, because if something happens, you're going to want to deal with it immediately, not, half an hour later. And there have been a number of deaths in assisted living from choking this past year, particularly aspiration, which is when some food gets into the lungs and causes an infection. Mm-hmm. And then someone has difficulty 3-4 days later and they have to go to the hospital. And many times, the outcome is not good in those situations. So it is a concern, but you have to temper that with, we are going to be under this HCBS regulatory environment. And, people eating in the room's not the only issue. Like I said, I think we're going to see visitation be an issue. If they want someone to stay overnight, you can't prohibit that. But when does that visitor start becoming a tenant in your facility? I mean, these are some really tough issues. And the last word I'll say on it is, if things become an issue, there is a place on the DHS website you can go to request a modification. It's called a modification. And you'll want to fill out the modification paperwork and submit that. Now, unfortunately, it's the MCO that gets to be the arbiter of that modification. Mm-hmm. I don't like that. I wish it was DHS because we don't know how reasonable the MCO is going to be. But there is a process to get something modified, especially I can see if someone wants to eat in a room and they have a swallowing difficulty. Now you got to dedicate a staff just to watch them eat. And how many people do you have with swallowing difficulties? So there has to be some middle ground. We can't have all these issues where the resident is absolutely right on everything, no matter what. There has to be some common ground and some understanding of what's best accomplished, what risk is the resident willing to accept. In the case something goes bad, we may have to do more and more. They're not necessarily risk agreements in CBRFs, but because you can do them with an RCAC, but mm-hmm. make a letter of understanding, and you're choosing to not follow your doctor's advice on your diet, or and diet could be a diabetic wanting cake all the time. That could be another mm-hmm. risk under HCBS. You got to let them do that. I just spoke with a client yesterday where they have 2 residents who, if the refrigerator's left unlocked, will go through all the sweets and all the liquids in the refrigerator to the exclusion of the other residents. And so I told her, you gotta seek a modification of the rule that there's the availability of food and snacks constantly there, so we will be, this is a big issue, Angie. We're going to be dealing with mm-hmm. this. I'm convinced.
Yeah. So should we as providers be taking a look at those resident handbooks? I'm just thinking off the top of my head, where you used to have your visiting hours or your when you lock the doors and all of those things. Are all of those, we should be taking a look at that and making sure we have 6 days to comply with these new rules, right?
I think you should. I think you should, because I would bet some of your resident handbook rules are going to be
in violation,
conflict
potentially,
with the HCBS rules that are that have rolled out and are going to now be enforced.
This is a difficult transition as a provider. And I'm also on the other side. I'm also a daughter in this situation with my mom living in assisted living, because I want to protect her and give her quality care. But, she has the right to choose, and she has the right to not make good decisions for herself. And as providers, it just seems so such a contradiction to what we're trying to do is safeguard and provide good care. So this is definitely, it's something we've been talking about, and it's definitely going to be an adjustment from the standpoint of when people want to make what we would think are bad decisions.
Right. And I
wanting
think
to
the other
eat
thing
in
you
their
might
room if
want to
they're
look
a choking risk, for example.
Yeah, and the other thing you may want to look at is your residency agreement. I mean, some people incorporate resident handbook type they don't necessarily have a handbook, but they incorporate those concepts into an addendum or an exhibit on their admission residency agreement. That may have to be reviewed to make sure it's in conformance with the new HCBS rules. And a lot of people can just benefit from a refreshing of that anyway. I mean, we do a lot of that work.
Yeah. Just when being a provider isn't challenging enough, here comes a new set of rules.
Yeah. Right. And you hope the regulators have been trained enough to think reasonably about this stuff. I mean, I know a lot of them have been providers or have given care even just in the hospital. So, hopefully there's some empathy and some realization of, you apply it black and white versus applying it in a way that's reasonable. I mean, they always talk about, I remember Alfred Johnson always talking about being reasonable regulators, and I hope that's the case when it comes to these HCBS. Well, not just HCBS, all the regulations. We're pretty heavily regulated in Wisconsin, so in assisted living, so it applies across the board, really.
Yeah, I was at that that state breakout CEO roundtable at the Wisconsin Assisted Living Conference, and one of the questions in there was brought up about if a resident doesn't answer the door, are we allowed then to enter the room if they're not responding? And one provider was talking about a surveyor had said, no, you'd have to call the police. Well, that's kind of counterproductive if you're a provider. You're there to check on people and their well-being. If it was my mother and she was not responding, that's why she's there. I want the staff to unlock the door and go in and check on her. And they did say that response was extreme.
Yeah, that is.
That they were going to address that from a surveyor standpoint. But that's one of the reasons why, and my mom, she likes to lock her door. She likes her privacy. She's in an RCAC setting, so she has her own apartment. But at the same time, when she's ill, we have all agreed, and she has too, that if she's not answering the door, please check on her.
Right.
She knows that's why she's there. But I think about that extreme. If it's somebody who says, no, don't check on me, I'd be, as a provider, I'm very conflicted because that's what we're there to do. That's why families like me move our loved ones to those places so that there are people there to check on them.
Right.
So
I agree.
It's navigating those issues that are important to families. And I want to say common sense. but not everybody has the same common sense, right? What one person thinks is common sense, not everyone does think is common sense. But I just am concerned with these rules of our ability as providers to, be able to just provide that level of quality care that we all want to provide without now being afraid of something else. So it will be an interesting time for us to navigate through, but we always get through it somehow.
Yeah. And I think that the surveyors in the survey agency itself will be tested a bit on, are they looking at the literal words on the page, or do they recognize that someone needs to be checked on if they don't answer the door? And you don't just call the cops every time, because pretty soon the cops won't be coming around if you call the cops every time. So, hopefully they are going to be reasonable regulators with regard to this new implementation, that another set of rules they have to be concerned with, but it remains to be seen. We'll see how that goes.
Right. And I think as a provider, you have to be able to speak out if something is, you feel unreasonable with the information that you get. I learned a long time in this industry, a long time ago, I learned that just because a surveyor says something doesn't mean it's necessarily right. And you do have the option of questioning any advice that you get, or, I think of with the exit surveys, we've been told, I've sat in them myself, we've been told things that are not correct. They're people too. And they might be misinterpreting something. So we always have to know. And one thing that I have learned in all the years is you can ask questions and find the answers if something doesn't seem right. That's what we have to do. But onto another question, how do providers reduce risk before a complaint becomes a legal issue?
Well, that's pretty interesting, because I guess one piece of good news is complaints are actually down for the first time in a long time from the data that I've seen recently. So that's good news. They're still pretty high, though. I always had heard from the Bureau of Assisted Living, and I agree with this, is if you're going to get complaints, keep them in-house. Keep them at the facility level. Because they can be dealt with much more quickly, they can be dealt with much more completely, and they can be dealt with to much more the satisfaction of the family or resident who has a complaint. The minute the residents are sort of conditioned to make their first call to the state, now they've started down a road that may not get them satisfaction, is going to cause grief for the facility, and is going to probably keep them unsatisfied, and many times continually making the same complaint. So I always tell people, just do the best you can to educate your residents that if there's an issue, come to us first. Designate a person. Now, the problem that has been traditionally told to providers from the regulators with that approach is that the person designated as the complaint receiver at the facility has not done always the best job of communicating back to the complainant, the family member or resident. So to me, that's kind of where the work needs to be. It's fine to preach like I do to keep the complaints in-house. It's another step to make sure the communication happens once the complaint is received, and then action taken to help resolve that complaint. And maybe it could be an unfounded complaint, but that's to me, the communication is key. You can overcome a lot of negative things just by communicating. And it doesn't even have to be communication that the complainant necessarily likes, but it's just the fact that you've addressed it and you're talking to them. It can overcome so many complaints. So again, that's another something I preach a lot is keep your complaints in-house and communicate with who is making the complaint. Now, we all know there are difficult residents, there's very difficult families, sometimes fractured families where half are reasonable, half aren't. But if you're communicating, I've seen a lot of those issues go away without the need for further intervention or for them to call the state. Now, some people are just going to call the state no matter what. You can't get past that. But you should try and educate your residents that we are the people that can solve your problems, not the state. Because the state hardly can ever solve their problem, but you can.
Right. We put in, when the state rolled this out at our company, we put in a QR code on a plaque in our entryways of our buildings. If you have concern, if you have concerns, submit them to us. And that goes to one of our general mailboxes. So that way, if they can do it anonymously or they can put their name on it. But that way we can, the idea that we had was trying to get more of those complaints instead of them going directly to state. Because although we're a very compliant company, it still takes a lot of our time for when a surveyor comes in and you've got to sit there all day with a surveyor, right? And so many things are unfounded. And we wanted to have a better way for families to feel like they could bring concerns forward to us. So we implemented that. That's been helpful. There's people that choose to communicate that way. And for us at the upper level management, we're able to see then some of the concerns because when we're running so many locations, we don't always know either. And that's been beneficial. So if there's other providers that wanted to piggyback on that idea, it's a great way to try to get people. It's not, some people thought, well, you're putting the sign out there because you're looking for complaints. Well, yeah, we sort of are because we'd rather get them than state is. And even we get good feedback on it too. We just want to let you know this location is doing great. We love the staff. And we probably get as many of that feedback as we do concerns. So it works both ways. And then, of course, we always share that back with the location. But that's been beneficial. That's one of the things that we implemented to try to facilitate more of our own concerns that come through. Because sometimes you get the complaint and you think, I feel bad for the surveyors that they even had to come out for that. Sometimes it's a legitimate concern. And I don't want to discourage a family if there is a legitimate concern and you need to call the state. That's what it's there for. So I don't want to discourage people from using that. But if it is something that you can address with the location, we would encourage that for them to be able to navigate through that. What would be your advice to a brand new administrator coming into the role and starting out? I had that round table at WALA where we were meeting with the students from the UW Eau Claire in the healthcare administrators course. And I couldn't help but think to myself, they have no idea what they're going to step into. It's a great career path, but there's so much to learn and do that you can't learn until you show up and you sit at that desk or walk those halls for the duration. But what would be your recommendations of somebody that's just walking into the building new?
Well, there's a lot of hats they wear, obviously. I'm kind of on the legal side and the regulatory side. So, that's kind of what I look at. In terms of being savvy, regulatory wise, just sitting down with the regs, at night, probably a good way to help fall asleep. But also, it's just good to review those because every time I read them, I always find something different or something I didn't know. But being aware of the regs and how you're implementing them, making sure your systems are working, making sure staff know that they can come to you with issues. Again, that's another that's another issue that we have, is not just families complaining, but our disgruntled employees complaining to the state. And just as I preach about residents keeping their complaints in-house, staff should really feel the same way. I mean, they should feel like they can come to someone and someone's going to listen and someone's going to do something about that. Because I think a lot of these complaints that get to the state are disgruntled current and former employees that generate. Those are often just lies and illegitimate complaints. They're just trying to get the facility in trouble. So, new administrators should feel comfortable with the regulations, should be able to handle a survey, and that's probably that first one they go through is not going to be very easy, but they'll get through it and they'll learn a lot from that. And then just, making sure staff understand their roles, and that if there's issues they can come to management, and management's going to listen to them and not turn a deaf ear to them. So I think those are the most crucial things. And then continuing to learn. I mean, all the associations in Wisconsin offer great programming. I know WALA has like a leadership skills course. I've heard that's excellent. And I'm sure Leading Age and WHCA also have courses that new administrators could benefit from. But just keeping their eyes wide open and not just being so narrowly on with blinders to what's going on in your facility, and expand your knowledge and continue to learn, continue to ask questions, network with other administrators in your area, in your region. DHS does offer networking events within the various regulatory regions, in getting to know, other administrators, maybe seeking out a mentor to help with issues that come up is something also I would encourage.
That's great advice, Bob. And I always say to anybody new that's starting out in the leadership role is that it's usually, for us, in all the years I've been here, 17 years now, so I've seen a lot of leaders, and it's usually about a 7-month to a year real learning curve before all the pieces really start to come together. And the more you can immerse yourself in your policies and your procedures and the regs and all of those things, but it does eventually, all the puzzles begin to fit together and come together. But it definitely is a learning curve. But this industry, we definitely need leadership. It gets leaner and leaner out there. And I want to encourage people to get into the industry. It's very rewarding in many ways, helping and caring for people. And there's a lot of directors that do an amazing job and make it a career and love doing it. So I think that's great advice. Well, I want to wrap it up for today. Thanks, Bob, for being on the show. I really appreciate it.
Great being here.
If leadership is in your heart, don't wait for someone to hand it to you. Start preparing now, learn the rules, ask better questions, pay attention to the details, and protect the residents and build trust. Because the executive directors are not just caring people, they are proactive leaders. And if this episode made you think differently about your next step in healthcare leadership, share it with someone you know who is looking to grow. Follow the Angie Graham Podcast and keep showing up for people that you serve, because the future leadership may matter more than you realize. So thank you to all the healthcare heroes out there, and we'll talk again soon.
Thanks, Angie.
For more of the Angie Graham Podcast, check out our YouTube channel or our website, theangiegrahampodcast.buzzsprout.com.